Shri Ashok Sahu ji.
We are all honored today by the presence of the most eminent, distinguished legal luminary of this country, Mr. Jetmalani among us. My obeisance to you, sir. Mr. Venkat Narayanji and friends. Right from the morning, we are all loaded with the dissection of this ignominious bill that has been in the womb of National Advisory Council, though it was in the agenda of National Integration Council, which was protested by almost all the chief ministers from non-Congress states, states ruled by non-Congress parties. And we thought that there is an abortion, a miscarriage, but you will be surprised to know, particularly those who will go into the internet, the AICC, that is another AICC, you know, there is one All India Congress Committee, there is another All India Christian Council. They have been insisting that this bill must come. And this has, I've seen it only a month back in the internet. That means there is no abortion as yet. This is still alive and it may come up anytime. And today, one of the speakers said, I think Mr. Ohri was telling, that they will just bring an ordinance and after that, they will pass this bill. Anything is possible in this parliament today, both the houses. And as Mr. Venkat Narayanji said, you know, the framers of the Constitution in the preamble said that we want the unity and integrity of this nation to be safeguarded. And later on, in the fundamental duties, when Article 51A was inserted by amendment, we said to uphold and protect the sovereignty, unity and integrity of India. Further, we said to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, to renounce practices derogatory to the dignity of women. Further, we said to value and preserve the rich heritage of our composite culture. This bill is designed as a conspiracy to finish all these noble ideas in our Constitution. This is a bill which is nothing but a strategy to divide the nation by unconstitutional means, by an extra-constitutional body called National Advisory Council. And the mother of this bill, as we all know, are the Godhra incident and aftermath in 2002 in Gujarat. But the bill which was framed in 2005 and the bill which is in the womb now to take birth in 2011 are two different bills. In 2005, whatever they had framed was very vehemently objected to by two organizations. One is JCMOE, Joint Committee of Muslim Organizations for Empowerment. Another is All India Christian Council. And after these two organizations objected, as far as I remember, in March 2010, the AICC wrote a letter to the President of India, signed by the General Secretary, Dr. John Dayal. It was February 2010. And on 31st March 2010, this National Advisory Council was reconstituted. And Mr. John Dayal was inducted as a member, along with Sahabuddin, under whose signature the Joint Committee of Muslim Organizations for Empowerment had sent their observations. So I think, again, because of the paucity of time, if I'm allowed by Mr. Venkat Narayanji, I will quickly read out only 2 pages out of this 7 pages, which is important, and the remaining, it is all discussed in the morning. And I will take 2 minutes more, so I am going to finish it. The National Advisory Council, constituted under the PMO with Mrs. Sonia Gandhi as its chairperson, comprising members handpicked by her as its chairperson since its inception in 2004 and reconstituted in May 2010, is bent upon drafting a bill designed to weaken Indian nation by widening the differences on the basis of faith, ethnicity, language, dialects, and divide the nation by dichotomy as dominant and non-dominant groups. The background of such an extra-constitutional body, armed with such legislative functions, which is part of sovereign prerogative in our constitutional framework, is the Gujarat riots of 2002. The initial draft bill was placed before the Rajya Sabha in 2005, which was strongly objected to by the Muslim as well as Christian groups and condemned as toothless, was compulsorily revised in 2009. Meanwhile, the Kandhamal incidents had occurred in 2008. 2 minority organizations such as AICC, All India Christian Council, led by Dr. John Dayal, and JCMOE, Joint Committee of Muslim Organizations for Empowerment, led by Syed Sahabuddin, insisted for making the state authorities accountable for failure to prevent any violence and protect the religious minorities. The bill was finally drafted in the present form only after inducting representatives from the AICC and the JCMOE and other known rabid anti-Hindu elements like Harsh Mander, Tista Settlebat, Javed. She is actually Tista Javed. Farah Naqvi, Syed Sahabuddin, John Dayal, Asghar Ali Engineer, Ram Punyani, Shabnam Hasmi, Upendra Bakshi, Brinda Grover, and Aruna Roy into the NAC. They redrafted the bill incorporating all their grievances and reframed the basis for the bill on the basic concept that in India, the targeted communities in the incidents of communal violence are necessarily the Muslims and the Christians, and the perpetrators are invariably the Hindus and their various associations. This association is very important. The draft bill on prevention of communal and targeted violence, access to justice and reparations bill 2011 is hence targeted against the 82% Hindus with intent to divide them and disturb the resilient harmony that is the hallmark of Indian cultural identity. It is a bill intended to be passed by the Parliament in order to enact a central law stringent enough to even punish the associations connected in the remotest manner to individuals alleged to have committed any offense under the intended draft bill for offenses only and exclusively where the victim belongs to any minority group. In case the victim is a Hindu, other criminal laws in the statute book would apply. The draft bill is intended to safeguard the interest of the minorities only. Even the public servants as a whole seem to be suspected of perpetrating communal violence would be made liable for punishment for not only their failures, but also those of their subordinates for breach of command responsibility and dereliction of duty, with sentences that may extend to 10 years of imprisonment. Even the non-public servant among state authorities can be roped in for criminal prosecution. The JCMOE even demanded President's rule under Articles 355 and 356 against the democratically elected governments in the states for such failures. Commenting on the 2005 bill, the JCMOE said, within inverted commas, the bill does not make police or administration or state authorities accountable and provide for timely and effective intervention by the National Human Rights Commission if the communal violence spreads or continues for weeks, or by the central government under Articles 355 and 356 of the Constitution duly modified. They want the Constitution also to be modified to punish the majority Hindus in this country. So, on the other hand, ironically, the bill grants, it is the allegation of the JCMOE, grants more power to the local police and administration, which more often than not acts in league with the rioters by declaring the area is communally disturbed area. The AICC complained, among others, the bill does not give states guidelines on reparations and compensation. We need a uniform national policy as well as standards and the assessment of damages after riots in order to prevent ghettoization. Here I would like to recall, I come from Kandhamal, the second mother of this bill. First mother was Gujarat rioting, second mother was Kandhamal incidents. And when in Kandhamal things were happening, in our country we are guaranteed equal protection of law and equal treatment of law. And Mr. Jetmalani will bear me out, when there is a writ petition on any matter directly coming before the Honorable Supreme Court, the Honorable Supreme Court says, why don't you go to your High Court? But in case of Kandhamal, a writ petition was allowed by then Chief Justice Mr. Subramaniam. And Mr. Subramaniam is a converted Christian, then Chief Justice of this country. And without hearing the other party, they give directives how to deal with the incidents happening in Orissa. We have been discriminated by the Honorable Supreme Court of this country. Then after a long time, when we intervened in that matter, the court is silent since then. That means natural justice was denied to us. We were being condemned unheard. When we were heard, the tone of justice became different. The language of the judgment became different. It's unfortunate. So once the charges are framed by the prosecution for offenses under this draft bill, the burden, again you see, this concept of breach of command responsibility and dereliction of duty, for which the army generals who are in command of containing civil disturbances, or the police chiefs in command of maintaining law and order, or the civil administration heads in command of maintaining law and order, they will be taken to task by the principle of vicarious liability. This concept has been brought from that Rome Statute of the International Criminal Court. And there is a background for it. Rome Statute of the International Criminal Court was thought of for those disturbances in those countries where there is no system, like Rwanda, like Czechoslovakia, Kosovo and Herzegovina, like many African countries where there is no system and human beings were denied human rights. But in our country, when we got a constitution with a separate chapter for fundamental rights of citizens, irrespective of caste, creed, religion, sex, how can such things be introduced to our country? If I accuse the National Advisory Council that it is acting as a handiwork of the Western countries to impose certain things, insinuating into the sovereignty of our country, I will not be wrong. These are all part of a design to separate this country on the basis of scheduled caste, scheduled tribe, religious minority, because 8% of this country are scheduled tribe, 18% country are scheduled caste, and the crypto-Christians and the Christian converted are 4%, and about 16% are Muslims in this country today. If you take all this together, I've given this in one paragraph, it constitutes 46%. On one side 46%, and on the other side rest of the Hindus, 54%. They want to divide this country. And then suddenly there may be some intervention of NATO members of countries led by USA. You know, USA, they have got a commission, United States Commission on International Freedom of Religions. They come out with reports on Gujarat and Kandhamal. And that guides this National Advisory Council. So whether we in India today, after 62, 63 years of our independence, we are ruled by our elected representatives or we are ruled by forces outside this country. Where is our sovereignty? Because with this last comment, I will finish my talk. Sonia Gandhi, she has sabotaged with our system. I am giving only 3 examples. She had selected a person superseding 3 persons who could have become Chief Justice of this country. One, Mr. Balakrishnan, to be the Chief Justice of this country. And Mr. Balakrishnan superseded Mr. Justice Agarwal, Mr. Justice Santosh Hegde, and Mr. Justice Pasayat. In normal course, these 3 persons should have retired as Chief Justice of India. But Mr. Balakrishnan was superimposed when we had Mr. Narayanan as President of this country. And Mr. Jethmalani knows about the background. This Mrs. Sonia Gandhi has put a person in the Rashtrapati Bhavan whose tenure is going to be over after 2-3 months as President of India, who was not known to the entire nation. Her only qualification is that as Governor of Rajasthan, she did not give the assent to 2 bills passed by the legislature of the state. One is the Freedom of Religion Bill, another was Prevention of Cow Slaughter Bill of Rajasthan, and that was her qualification. And the third thing she has done, she has kept a person of this biggest democracy of the world, India, with the highest population in a democratic country, more than that of United States. A person as the Prime Minister who is not elected to the House of the People. For more than 7-8 years, he is the Prime Minister of this country. We are tolerating him and we still take pride that ours is the biggest democracy and we have a Prime Minister who is not elected by the people to the People's House of the People. He is indirectly elected by MLAs of Assam. He is representing the Rajya Sabha. So this is sabotage of the system. Because she was not allowed to be Prime Minister by then President Mr. APJ Abdul Kalam, she has shown the way to this nation and she is ruling this country. And this NSC is constituting drafts, bills which are placed before the Parliament, which is the prerogative of the sovereign legislature. And on top of it, to give recommendations, we have got a Law Commission of India, duly constituted. It is not by executive order. Law Commission of India has been headed by eminent jurists and headed by a retired Supreme Court judge or retired Chief Justice of the country. And they don't frame bills. And here is an extra constitutional body which is framing a bill which, on the face of it, directed against the majority people of this country. Now, whether the bill comes or not, we question the very audacity. With what audacity this bill has been drafted and placed before National Integration Council. A strategy to break the integration of this country was placed before the National Integration Council in their agenda. So with this I finish. I think by this time we all know what is there inside and outside this bill, and we will never allow our nation to be sabotaged by an outsider. Thank you all. Bande Mataram.